Welcome everyone to our LinkedIn Live. The topic for our LinkedIn Live today, make sure you're in the right place. It's New York City Local Law 144. We're going to talk more on the requirements, what this means for artificial intelligence solutions in hiring, what this means for employers, and some insights we have along the journey of learning about this law. So without further ado, I will present. Great. So first, a disclaimer, your classic disclaimer: nothing is intended to provide and shall be interpreted as legal advice. Especially meaningful to cover our disclaimer about today's topic. Everything here is for general information. Nothing contained herein shall be interpreted as an admission around NYC local law applying to HiredScore software solutions, and nothing contained herein takes a position with respect to interpretation or application of New York City law or any other law or regulation to HiredScore's products and services. Great. So about me, my name is Athena Karp. I am the CEO and founder of HiredScore. HiredScore provides artificial intelligence solutions for human resource professionals focused on talent acquisition, talent management, total talent, and workforce planning. I started HiredScore a decade ago, always with a vision of how do we make hiring more fair and efficient. And what we've been really excited to bring to market, over 40% of the Fortune 100 across many of the Fortune 500 today, is even deeper impact in fairness and efficiency, not just in hiring, but in promotions, in workforce decision-making, and more. So glad to be here today. In short, this topic, this I imagine to be one of many of the local regulations, the federal regulations, and even international standards that are being either discussed or passed or signed into law or into best practices. And in many ways, it's really an exciting time. My background before starting HiredScore focused on healthcare, and that was a place where you saw artificial intelligence solutions come to life much sooner than they did for the HR space. And there was always a notion of regulation there, whether that's explainability, auditability, transparency, and assuring that they were safely innovating and never innovating without that safety measure. And what we see today is the world is really paying attention, not just to ethical AI, but how artificial intelligence applied to human resources can have the same level of transparency, explainability, and auditability. When we think about HiredScore, particularly relevant for us because we've thought on our journey well ahead of any regulations coming to life on what does that gold standard of ethical AI, what's that definition of compliance that goes far beyond personal data privacy, that goes far beyond data use, safe data use, and governance. And really that comes down to, bias testing, artificial intelligence solutions that are tested client by client, application by application, that are fully explained and auditable, and that understand that local compliance for global solutions often mean many different things, whether that's South Africa law, New York City law, US law, UK law, Canadian law, Brazil law. In some places they contradict, in some places they go much deeper, and in other places there are tangible global standards. And so just what that means, it has been really exciting, and carrying with us the different best practices brought to different geographies. So when we think about New York City, bias audit legislation, this local law 144, what I think is especially tangible is this notion that, automated decision-making tools actually require certain level of governance, certain level of clarity, certain level of auditability, that this is really a first of its kind law being passed. And important to note, this law began its journey. For example, I testified for this law back in November 2020. This law was supposed to go into effect January 1st of 2023. Actually, the law today was postponed until April 15th due to open questions and some items that can continue to request clarity from the public. And I think that doesn't in any way negate some of the content we're going to talk about today. I do think it just shows the newness of laws like this, that there are such follow-on questions, there are such new standards being brought to life, and especially this one, which is instructing employers for their obligation when using these automated tools. And because of that kind of first of its kind, that there's a lot more clarity that's needed. So when we think about this Local Law 144, it was passed December 2021. The law regulates the use of automated employment decision tools in hiring and promotion decisions within New York City. Interesting, it applies to both external talent and internal talent. It really applies, as mentioned, to requiring employers to follow a number of different protocols and practices, to use AI tools that undergo an annual independent bias audit with a publicly available summary. This is probably the most talked about item that we hear in the market of this law and its ramifications. Provide candidates, both internal and external, with 10 business days notice prior to being subject to such AI tools. Disclose job qualifications and characteristics used by the tool to make its assessments. Clarify publicly or upon written request sources and types of data used by the tool, as well as disclose applicable data retention policy. And I think important to note, automated employment decision tools, what qualifies as one of those, what doesn't. There's a wide segment of solutions in the HR technology space, and really important to dive deeper into, for every TA leader and HR leader, what are the tools that you have activated? What laws apply or don't apply to them? Does this New York City law, if you hire or have employees employed in New York City, apply to you? And how do you then make sure you comply? Important, as we're following the New York City Local Law summary, we often get asked a lot, specifically around this bias audit. And this law does talk about auditing the artificial intelligence, even though HiredScore's applications do not influence or replace decision-making. We can comply with New York City law in such that the tools used do not create a bias by statistically favoring one group over another of protected characteristics. And this is where I think we get deeper into, what does this law mean for employers? How might you look at companies that you work with, whether it applies or doesn't apply to them, supporting employers' requirements under this law? And are there things that vendors can do above and beyond what is specified from the employer to ensure that employers are ready, and that all technologies and tools, whether they actually influence or replace decision-making or not, meet that highest possible standard of auditability, explainability, maintaining a variety of support for opt-out preferences and configurations that a client might have, and really supporting the employer along the journey with how to have solutions that, whether or not this applies to them, still meet criteria of ensuring that similarly qualified people are treated similar. So definitely an exciting time, and a time when we feel there is a lot of change in the regulatory environment, and especially for citizens going through job applications or jobs hunts and processes that actually really just want to understand that the tools leveraged to, for example, consider them or recommend them, or in some tools cases, not in HiredScore's case, but in other tools cases, they might be knocked out entirely from that process because of an assessment test or a video interview or a game that they took without realizing what that tool cares about, what it doesn't, what that means for them, what it doesn't. In the case of HiredScore, we don't come up with criteria of what makes someone good. That's fully transparent to every candidate in the apply process as per the rec, which is what HiredScore leverages to determine if someone has the qualifications defined in the job or not. But I think important to note that there is a real human concern that they don't know what good looks like. They don't know what they'll be considered against, and they don't know whether that will mean they're knocked out knowingly or not. And a lot of these tools are kind of, a lot of these regulations are brought to life to try to bring a level of consistency, clarity, and governance to ensure that technology is safely used that impacts people and jobs. So I'll pause there and see if we have any questions. Great. Well, thank you so much for joining our LinkedIn Live. I hope this was informative. I hope it was helpful. Feel free to scan the QR code here on this last slide if you want to get in touch with any member of the HiredScore team, HiredScore account team, or HiredScore sales team with any additional questions of what's happening in compliance and AI, what's happening in ethical AI, or otherwise. So we have one question. What was the reason for the New York City law delay? Great question. So I wasn't part of the, I'm not part of that in any way, shape, or form, but what we heard that the Department of Consumer and Worker Protection put out this morning was due to the high volume of public comments. They're planning a second public hearing. And due to that, they are going to delay. We did hear also that a number of people that tried to get into prior hearings weren't able to. So I don't know if that had anything to do, but definitely I think the overwhelming amount of questions around the regulations led to, and around the proposed rules being implemented, and seeing what those rules were, what they meant, what that meant companies had to comply with, led to a delay. There's a great article for those wondering, actually, on VentureBeat, which I'll share here, that has more information on that delay. Great. Other questions? Well, thank you so much for joining, and look forward to seeing everyone from the LinkedIn community on future LinkedIn Lives.